Welcome to this explainer. Today, we're going to dive into and really demystify a system that millions of families navigate every single day. I'm talking about the complex and, let's be honest, often intimidating world of special education in America. If you've ever looked at the dense web of special education laws, it can feel like you're reading an entirely different language, right? But at its core, this legal framework is actually a deeply personal roadmap. It's a journey that's designed to take a student from early identification all the way to independent adulthood. So our goal today is to break down that roadmap, step by step, so you can see exactly how it works, why it matters, and how it truly shapes the lives of neurodivergent and disabled students. Let's get right into it.
We have a highly structured roadmap ahead of us today. First, we'll look at the fight for educational rights. Second, the child find mandate. Third, IDEA versus Section 504. Fourth, defining an appropriate education. And finally, transitioning to adulthood.
All right, Section 1, the fight for educational rights, laying the legal groundwork.
Okay, let's dive into this timeline. Because, the educational rights that disabled students have today, they didn't just appear out of nowhere. They were incredibly hard-fought victories built right on the bedrock of the civil rights movement. In 1954, you have the Supreme Court's landmark Brown v. Board of Education decision, which struck down the whole separate but equal doctrine, essentially ending race-based school segregation. Well, disability rights advocates looked at this and said, wait a minute, if separate is inherently unequal, then excluding the estimated 7 million disabled children from public education, well, that's unconstitutional too. And that exact logic provided the blueprint for the 1972 Park and Mills cases, which successfully extended educational rights to disabled students. That momentum spread like wildfire, leading directly to the 1975 Education for All Handicapped Children Act, guaranteeing a free public education. And then, by 1990, this evolved into IDEA, the Individuals with Disabilities Education Act, which really shifted the focus to people-first language.
And that brings us to the 7 core principles of IDEA, which are absolutely crucial. These are the fundamental rules governing special education today. You can kind of think of these as the Bill of Rights for disabled students. We have the guarantee of a free, appropriate public education, or FAPE, delivered in the least restrictive environment, which basically means keeping students with their non-disabled peers as much as possible. Every single child gets an Individualized Education Program, an IEP, a customized roadmap just for them. Assessments must be non-discriminatory, parents absolutely must be involved, and families have due process rights to resolve disputes. But honestly, perhaps the most profound principle here is zero reject. Literally no public school can turn a student away because their disability is too severe. Everyone belongs, period.
Moving on to Section 2, the child find mandate, early identification.
So, now that we know these rights exist, you might be wondering, how does a student actually begin their special education journey? Well, the first crucial step is child find. And the crucial point here is that this is an affirmative legal mandate. Schools cannot just sit back and wait for parents to come in and beg for an evaluation. Nope. Districts are legally required to proactively identify, locate, and evaluate all children with disabilities from birth through age 21. And here is a vital detail you definitely need to know. This applies even if a student is advancing from grade to grade and getting passing grades. If a school even suspects a disability is impacting a child's learning or behavior, they have a legal duty to act. To give you an idea of the sheer scale of this responsibility today, consider this staggering statistic. Over the past 45 years, the number of students in special education in the United States has doubled. We are literally looking at a 2x growth multiplier. This underscores just how massive and, frankly, how modernly relevant the child find mandate is. Schools are identifying and supporting more neurodivergent and disabled students right now than at any other point in history.
And let me tell you, there are very real, very high stakes if schools drop the ball on this. Courts have consistently held districts liable when they ignore parents' requests or delay evaluations. For example, there was the WB versus Matula case, where a mother repeatedly asked for help for her son, but the school just stonewalled her for months. The court actually found that school officials could be held liable for monetary damages for persistently refusing to evaluate the child. Wow, right? In another massive class action case, Jamie S. versus Milwaukee Public Schools, a judge found the district failed to implement child find for at least 5 years, which led to huge demands for compensatory education for a massive class of students. The takeaway? The law absolutely does not mess around when it comes to early identification.
Section 3, IDEA versus Section 504, choosing the right path.
Now, once a child is successfully identified, the school has to figure out the right framework to support them. And this brilliantly illustrates what that looks like. You'll typically see a choice between two distinct legal paths. On one side, you have IDE, which results in an IEP. On the other side, you have Section 504 of the Rehabilitation Act, which results in a 504 plan. Now, while both are obviously designed to help students with disabilities succeed, they operate under entirely different standards, different eligibility rules, and vastly different levels of specialized support.
Let's break this down a bit more. To get an IEP under IDEA, a student has to fall into one of 13 specific disability categories. Things like autism, specific learning disabilities, or hearing impairments. And they must specifically require specialized, individualized instruction to make progress. It's a highly structured, rigorous educational program, and because of that, it places a strict financial and administrative burden on the school. Section 504, on the other hand, is much more of a broader civil rights law. A student qualifies if they have any disability that substantially limits a basic life activity. So a 504 plan doesn't necessarily alter the curriculum itself. Instead, it provides accommodations, think extra time on tests or physical ramps, just to ensure the student's educational experience is comparable to their non-disabled peers.
Which brings us to Section 4, defining an appropriate education. What is FAPE?
Regardless of whether a student has an IEP or a 504 plan, the law guarantees them a free appropriate public education, or FAPE. But I really want to pose this pivotal question directly to you. What exactly is an appropriate education? I mean, does it mean the school has to maximize a child's absolute potential, or does it just mean providing the bare minimum so they can pass their classes? It's a tough question, and how courts actually measure a child's academic and social potential has shifted pretty dramatically over the last few decades.
Let's look at two totally defining Supreme Court cases to see this evolution. Back in 1982, the court heard the case of Amy Rowley. She was a deaf kindergarten student whose parents wanted a sign language interpreter for her. But because Amy was already getting passing grades and advancing, the court actually ruled against her parents. They established what became known as the Rowley Standard, stating that schools only needed to provide a basic floor of opportunity that offered just some educational benefit. Fast forward 35 years to 2017, and we get the Andrew F. case. Andrew was an autistic boy whose IEP simply recycled the exact same goals year after year without him progressing at all. His parents argued that a basic floor just wasn't enough anymore. And this time, the Supreme Court agreed, significantly elevating the standard. They ruled that an educational program must be reasonably calculated to enable a child to make meaningful progress appropriate to their unique circumstances. So just skating by, that is no longer the legal standard. However, actually achieving that meaningful progress requires some pretty fierce advocacy. In 2005, a Supreme Court decision called Schaffer v. Wiest dramatically changed the stakes here. Prior to this, if a parent disagreed with an IEP, the school district actually had to prove the IEP was good enough. But Schaffer v. Wiest flipped that burden of proof entirely. Now, if families dispute a plan, the burden falls squarely on the parents to legally prove the school's IEP is inadequate. This massive legal pivot really explains why parents today have to be such heavily informed advocates, often needing to go out and secure their own expensive independent evaluations just to ensure their child's rights are being met.
And that leads us to our final section, Section 5, transitioning to adulthood beyond K-12.
Everything we've discussed so far leads right here, because ultimately, the goal of special education isn't just about surviving high school, it is about thriving in adulthood. So let's move to and see how this builds into actionable steps, because transition planning is actually built right into IDEA. Step 1, planning must officially begin by age 16 under federal law, though some states, like Kansas, actually start as early as age 14. Step 2, the IEP team has to pivot from just academic goals to post-secondary goals based entirely on the student's own unique strengths, preferences, and interests. Step 3 is absolutely vital, partnering with outside agencies like vocational rehabilitation or independent living centers to secure resources early. And finally, Step 4, the ultimate pursuit of employment, college, or independent living.
This is a vital leap. Looking at this, it's all about bridging the gap from the familiar, structured environment of the K-12 schoolhouse directly into real-world career and adult transition services. This is where education meets real life. Schools are legally obligated to help build this bridge, ensuring students don't just fall off a cliff when they age out of the system at 21.
Which brings us to our final thought today. We've seen how hard-fought these rights were. We know the mandate to find and educate these children is powerful, and the standard for their education has literally never been higher. But with special education enrollment effectively doubling over the last 45 years, we really have to ask ourselves,
Is our system, our colleges, our workplaces, our communities truly ready to support this continuing surge of neurodivergent and disabled students as they transition into the adult world? It's a massive question, and one that challenges all of us to look beyond the classroom and rethink how we build a truly inclusive society. Thanks so much for joining me on this explainer, and keep learning.